Good evening, ladies and gentlemen. Welcome to the December 27th, 2017 Zoning Board of Adjustments meeting for the town of Merrimack. If you could all rise for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome, Kathleen Stroud, our new ZBA member. Kathleen, Kathleen's going to be sitting in tonight for Tony, who's going to be out, and Lenny will be sitting in for Fran, who is out this evening as well. The next zoning board meeting will be on January 31st, 2018. Rich, if you could read the preamble.
Absolutely. Good evening, ladies and gentlemen. We will proceed with the petitions in the order they are listed on the agenda, unless the board deems it appropriate to take a petition out of order. The state law and local ordinances set out the criteria that must be met in order for this board to grant a request. The minimum requirements are outlined on the form provided by the Community Development Office, and the petitioner should proceed with this format to provide adequate justification for the board to grant the request. The chair will open the meeting to hear testimony either for or against the request. All discussion will be between the speaker and the board. Please be respectful of all. In the interest of time, refrain from repeating previous testimony. No new documentation will be accepted by the board for consideration this evening. But the board reserves the right to ask for additional testimony at any time. After hearing the facts from all parties regarding the petition, the chairman will close the public hearing and the board will deliberate and vote on the request before moving on to the next petition. Please turn off all cell phones and pagers.
Thank you. If you plan on testifying this, well, a couple of cases, we're hearing two items this evening. One is an appeal for administrative decision, and the other one's a request for rehearing. The request for rehearing, the appeal for administrative decision is listed as item number 3. We're actually going to move that to item number 4, and we are going to hear the request for rehearing, Dan Ricker of 12 Merrill Lane, first. Now, due to zoning board bylaws, there is no public testimony for the rehearing. The request for rehearing is a discussion that is done by the board up front, and I know that there's quite a few people here this evening for that, but there will be no public testimony for that. There will be public testimony for the appeal of administrative decision. So, if you're here for the appeal of administrative decision, and you plan on testifying this evening, please stand to be sworn in. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. All right. You have a seat. All right. The first one that we're going to be hearing this evening is listed as, thank you, Dan Ricker of 12 Merrill Lane, request for rehearing regarding case number 2017-39, in which the board voted to grant the variance under section 3.08.9 of the zoning ordinance to permit the existing improvements, barn, shed, home, etc., to remain within a 100-foot landscape buffer proposed as part of the cluster subdivision. The parcel is located at 6 Watkins Road in the R Residential and Aquifer Conservation Districts and Wellhead Protection Area. Tax map 4C, lot 449. I'm going to be reading into record a letter, which is what we are using as the basis for the request for rehearing, that was written by Dan Ricker. This is the information that we have this evening for the request for rehearing. We are not accepting any other information or testimony on this matter. I'll now read the letter in. Dan Ricker, 12 Merrill Road, Merrimack, New Hampshire. I'll leave the phone number out. December 5th, 2017. Dear Zoning Board Committee members, motion for rehearing Chapter 677:2. I'd like to formally request a motion for rehearing in regard to the variance that was granted on November 29th, 2017 Zoning Board of Adjustment meeting. The applicant, William Listowska and Land Goshen LLC, was granted a variance from section 3.08.9 of the zoning ordinance to permit the existing improvements, barn, shed, home, etc., to remain within a 100-foot landscape buffer proposed as part of a cluster subdivision. I believe that a motion for rehearing is warranted because the applicant is asking for a variance from the required 100-foot landscape buffer. Section 3.08.9 Town of Merrimack Zoning Ordinance and Building Codes. 1. A cluster subdivision shall have a 100-foot landscape buffer to provide adequate transition from abutting landowners. The applicant argued that the spirit of this buffer is to provide a separation from a subdivision and commercial industrial space. That point was also reiterated by Leonard Worcester. I disagree with this argument because the 100-foot landscape buffer should provide a landscape screen from the proposed development and all current abutters. The spirit of the ordinance should be enforced whether the proposed property is abutting a commercial setting or a residential setting. The public needs confidence that there will be a physical separation from current owners and potential new cluster subdivisions. The proposal of the ordinance is to keep adequate transition from abutting land while keeping a tranquil, peaceful, and pleasing aesthetic appearance from the current homeowner's neighborhood. I believe that it is the applicant's responsibility to, quote-unquote, fit their project within the ordinances set forth by the town of Merrimack. I understand that every case is different, but when buffers/boundaries/property lines are involved, the board needs to respect the ordinances for current and futures homeowners. This project has 23.9 acres, and they can't figure out a way to abide by the 100-foot landscape buffer. Either they did not anticipate any noticing the discrepancy, negligence, or something else. The applicant should explain why another solution can't be reached. Thank you, Dan Ricker. To the board, based upon this letter, and it is in your packets for review, and based upon the information that was provided in the last meeting that granted this variance, what are the discussions, thoughts as far as grant, and this is in regards to not the plan itself so much as the request itself to have this reheard based upon the evidence that has been provided by Mr. Ricker. I open it up to the board.
Pat, is there any new evidence that Mr. Ricker has provided that would show that we did not act in accordance with our guidelines?
The only thing that I can determine is that he felt that, and hold on a second, I apologize because I would say the spirit of the ordinance was not observed. So he felt that they did not meet the spirit of the ordinance, which is one of the criteria that is required for approval of property.
One of the things that he's mentioned here was that the board shall, and that's in our our zoning ordinances. But one of the reasons that we have a zoning board is to provide exceptions to our zoning ordinance. So that if we look at a specific project and it otherwise fits our guidelines, but for some reason it doesn't on an individual case, then we can make an exception, and that's allowable by law.
Yes. That's it. That's provided.
And I think that's
provided that they made reasonable.
And I think that's what we've done.
Okay. Rich, Lenny?
I'll jump in. When you look at the cluster residential development regulations, promote the conservation of natural environmental issues. Establish living areas within the town that provide a balance of different types of uses. Provide an efficient use of land, streets, and utilities. Stimulate approaches of land and community development. They have an option. It's called a grid pattern project. They can chop up that 12 acres of open space into house lots. It will be all fragmented. Now, Mother Nature gives us one of the nicest things in the world. It's called snow. If you were out there within the last day or so, you'll see the amount of tracks that are out there where natural deer, etc., are traveling through that parcel up through the Watkins compound parcel. Keeping that extra 12 acres of open space only makes sense. If they did a grid pattern, this house, this barn, and everything can remain as is, just like it has in the past. What is the gain? There's no gain to saying tear the barn down and move the house. There's no gain to the general public. I don't think we err in any way. It's a small issue of a barn being 40 feet too close to the buffer zone. And that's what it all boils down to.
If we, and I looked at this and I said, rather than doing the number of house lots they're talking about, what if they did less? Would that fix the problem? If we went to a one-lot cluster, now that's not reasonable, but if we did that, that barn would still be within the 100-foot buffer. So reducing the number of lots isn't going to change that.
Okay. You sure about that? Are you sure? I mean, by reducing the number of lots?
The problem is that house is on the initial entrance to that whole lot.
Mm-hmm.
And the barn is on that lot. If we did this as a one-lot subdivision, or one-lot cluster,
Mm-hmm.
in that house, the barn and the shed, were the cluster, they would still fall within that, or the barn would still be within that 100-foot buffer.
Oh. Kathleen, comments? Rich?
One of the things that Lynn brought up that I didn't really, I guess, take into consideration is that a lot of the points that were made in the letter were reiterated. So at this point in time, there would be no new evidence against things. There was no new information that's been brought forward that we did not discuss at last month's hearing.
Okay. Okay. I'm just looking back over the notes from last month's hearing and looking back at some of the things that I remember saying and talking about, and I actually brought up the spirit of the ordinance. Attorney Michael disagreed with me on it, but that's one of the reasons why I moved the way I did during that whole meeting. So I am honest with you. To be honest, I see where Mr. Ricker's coming from. Because that was basically a lot of what I stated as it related to spirit of the ordinance. So I kind of see where he's coming from. If there's any other further discussion items, there's either a motion to move forward for a request for rehearing or a motion to deny the request for rehearing at this point, unless there's further discussion items.
I'll move we deny the request for rehearing regarding case 2017-39, in which the board voted to grant the variance under section 3.08.9 of the zoning ordinance to permit the existing improvements to remain within the 100-foot landscape buffer proposed as part of a cluster subdivision. The parcel is located at 6 Watkins Road in the R Residential and Aquifer Conservation Districts and Wellhead Protection Area, based on the fact that there was no new information provided and no error made on the part of the board.
Do I have a second?
Second. Oh, sorry.
Okay, Kathleen, second. All in favor, say aye.
Aye.
All opposed? Abstain? 4-1-0. I abstain. I voted in the negative. Thank you. Okay. Request for rehearing has been denied. Next is the David Paul and Tony Paul, petitioners owners, appeal of administrative decision as per the requirements of RSA 674-41. The RSA states that building permits cannot be issued to lots not meeting specific requirements and outlines an appeal process to the Zoning Board of Adjustment. The parcel is located at 312B Babusick Lake Road in the R Residential District, tax map 6A-2, lot 059-09, case number 2017-34. Can you gentlemen make sure you sign in? Also make sure that the light is bright green. I know it's probably green right now, but light green, tap on the mic if you're not sure if it's on. Yes. Oh, and Lenny is going to be abstaining himself for this.
Unless there's some other urgent issue, I'll just leave.
Happy New Year. Well, actually,
Wish everyone a happy new year.
You're going to vote for the,
I concur
The
with
meeting minutes?
of the last meeting.
okay.
that being said, because Lenny is abstaining himself, I will state right up front that you now have 4 voting members, which means that you need to have at least 3 vote in favor. If you do not, if you get a deadlock, 2 and 2, actually, you know, we have.
Yeah, you're 2 and 2.
If you get a deadlock, 2 and 2, the motion is denied. So you need to get at least 3 in favor for the motion to move forward.
If you want to continue.
It's your option if you want to have it heard this evening or have it continued.
Yeah, we'll move forward.
Move forward, okay? So noted. All right, if you just state your name, give us kind of a brief overview of what we're looking at here and go from there.
My name is Joe Mitchell. I'm an attorney in town, and I'm here to represent the
Make
interest.
sure your mic's on.
It's green.
Pull it
Push the
close.
button.
Not green enough.
There
There you go.
My,
That's okay. Everybody happens to everybody.
my name is Joe Mitchell. I'm an attorney here in town, and I'm here to represent the interests of the Pauls. And with me on my right is David S. Paul, who's the son of the record owner, who is seated on the front bench, who's Tony Paul, and her husband, David N. Paul.
Okay.
We are here to ask for an appeal for an administrative decision to deny the Pauls a building permit. The building permit is seeking to do several things. They've had a structure on their property since the building permit was originally approved in 1987 to have a garage constructed which is 3 bays wide on the first floor, and on the second floor was a living unit to be constructed also, which was completed in 1987, 1988, and for which they have been taxed as an occupied living unit since 1997. They are seeking to do some interior. First of all, the outside footprint stays the same. The outside appearance stays virtually the same. They are seeking to renovate the upstairs living area to modernize it and to change, specifically to change the wiring and some of the interior structure. They're also seeking to hook up to a brand-new septic field which services 3 different buildings in that area. 2 of them owned by the Pauls and 1 of them owned by an abutter. The Gray family is here tonight, which is the other abutter. And the third thing is to add a deck to the west side, which faces the lake. The deck would service the second floor of this unit, which, again, is the living part of this building. If I might address several things, I'd like to briefly go over the memorandum authored by Mr. Robert Price, dated December 20th, 2017, and then to be followed by the son, David S. Paul, who would like to read a statement into the record for the board's consideration.
Go ahead.
The memorandum of December 20th says in the second paragraph on the first page that the petitioner seeks to permit the construction of a dwelling unit on the property to be housed within the existing barn and garage. We believe that to be factually inaccurate because we are not seeking to construct a dwelling unit. We are seeking to change the interior of this unit only. This has been a building permit that's been around and approved since 1987 and occupied since at least 1997. So this is not a new construction. It is an alteration on the interior, principally of an existing structure. It also talks about there being a portion of Jeb Road. Jeb Road has been around since, I think it was surveyed, there's a plan that says it was surveyed around 1916, and it services a number of houses along the eastern shore of Babusick Lake Road. This end of Jeb Road was discontinued in 1997 by then the Board of Selectmen. Somebody wanted to build a neighbor wanted to build a garage over Jeb Road. This blocks our access to it, and the Pauls at that time assented to the termination of that end of the road, and the town terminated it. Therefore, there is no access to Jeb Road. The memorandum goes on to say on page 2 near the bottom that the staff is recommending that this be considered to be a petition as though it is a new construction, and we believe that this is not a new construction. It has been existing for over 3 decades and taxed by the town for over 2 decades as an occupied unit. I'd now like to ask Mr. Paul to read his statement into the record if the board would so permit.
Go ahead.
Thank you. First of all, I want to warn you, this is several pages, but it's double spaced, so it'll go quick. Our desire is to remodel our already existing property at 312B Babusick Lake Road, and the following is a brief overview explaining the need for the change we're requesting and the hardship we're facing and trying to avoid. The change is actually a continuation of a plan that we have had since 1987, when the town of Merrimack allowed us to take down the old cottage on the lake and replace it with a new garage with an apartment above, which is set up off the lake a bit further than the cottage was at the time. The improvements we plan will only benefit our family and neighbors by continuing to protect the lake and shoreline environment. The following is a brief history of how things unfolded. My great-great-grandfather was one of the first to settle at a camp on the Merrimack side of the lake. My grandmother grew up here vacationing as a child, and eventually she and my grandfather purchased the camp from her family. My grandmother's sister and her brother-in-law, my great-uncle Harold Rand, also purchased the camp right next door. In the 1960s, my grandparents, Gordon and Ruth Paul's camp burnt down and was a total loss. At that time, my grandparents then rebuilt the camp to a single-family year-round home, which my parents, Tony and Dave Paul, were able to purchase from my grandparents, and it's the home my sister and I grew up in. During the 1980s, my parents purchased my great-uncle's cottage next door. Since the cottage was very old with an outdated septic system, at that time the town of Merrimack gave us a permit to replace the cottage and build the garage and apartment back further on the property, which technically is now what's in question. The town gave us permission to build the garage further back, and we expressed that in the future we would like to replace the cottage living space by making a small one-bedroom in-law apartment which my parents could use for retirement once my wife and I were ready to purchase the main house. During 1995, we completed the apartment above, and since 1996 it has been occupied, and we have been paying taxes on this apartment as living space now for over 21 years. We should not even be here today, and we wouldn't even be here if we had just went ahead and remodeled the apartment and hooked up to the new septic system. Everything would have remained the status quo. Remind you, there has been no problem for over 21 years with the apartment being occupied, and now when we want to have my parents retire, as planned for over 30 years, there is all of a sudden opposition. The only reason we are here today is because we needed to obtain a building permit in order to upgrade the electrical entrance cable and build a deck. When we went to obtain a permit, which we already got in 1987, and our opinion is we shouldn't need, something we never imagined came to the surface. Now, a problem stems from a change made during the 1960s. My grandfather, Gordon Paul, and also William Jebb of Jebb Road, Jeb is 4 camps down the lake. They both together proposed and implemented an idea that would allow each neighboring landowner between my grandparents' camp to over several camps past Jeb's camp to purchase the property between the lake lots and the back lots that were towards Babusick Lake Road. This allowed each of the homeowners the opportunity to purchase the back lots to protect them from future development, therefore protecting the land and shoreline property from similar septic runoff problems that can occur over the years we see in similar neighborhoods. So my grandfather and Mr. Jeb were doing what we all now commend and we are happy about. Nobody, especially our family, wants any more building. The problem for us now is the garage is actually just over the property line in the back portion of lots which are protected from future building, per my grandfather and Mr. Jeb. My grandfather, who we just lost a little over a year ago, 2 weeks prior to his 100th birthday, said that he had no intention of affecting the cottage or the garage with he and Jeb's back lot plan. In 1987, the town building department decided to grant us a permit for construction of the garage and apartment, which happens to be just over the property line of the back lots considered unbuildable. The town allowed us to do this in '87 because, in this case, we were just replacing the old outdated cottage. So why does a law from 1960 affect something built and lived in since 1987? In '87, there was no Shoreline Protection Act. We were the protectors of the land. Our intention and only intention was to protect the land by removing the old cottage and old septic system. But we didn't want to sacrifice the living space of the cottage. In retrospect, we should have just replaced the cottage as countless other landowners around the lake have done over the decades, instead of moving the structure further back, arising this complication. We do not intend to change the landscape, the structure, or the footprint of any structure. We just want to use the brand new septic system already installed. We have tried to properly prepare so that both abutting neighbors and the town interests are best suited by gaining approval and acceptance by the abutting neighbors. In fact, we have a majority of our abutting extended neighbors and members of the Babusick Lake Association attending tonight. We have many friendly neighbors here tonight who support us, and we are all conscientious about protecting the lake, the shoreline, and the surrounding community. And in over 21 years, no abutting owners have ever expressed concerns or issues with the garage and the apartment. And the opposing neighbors are the same neighbors that have been there since way before 1987 when we built the structure and never raised a concern until now. In fact, all of our neighbors expressed approval as we told them what our plans were. We hear today that their argument is that if this is approved, it will set the precedent for buildable lots in the back. This idea is absolutely ludicrous. We are not even putting a shovel in the ground. The last thing we want to do is build anything else in this area. We just want to let my parents retire in peace without struggling. So in conclusion, a couple points to know. First, the septic for the home and our neighbors has been newly installed, inspected, and approved August 2017, which is a 10-bedroom septic shared between properties. Second, engineered plans are completed to reconfigure the driveway to grant an easement for the garage and the house to have its own driveway rather than using the existing right-of-way. This was with the approval of the same neighbor, Ken Gray, on the other side. We propose that we slightly reroute the driveway to access the detached garage and apartment and our main house separately. It should be noted that the existing road was accessed for 5 houses and cottages, but currently only accesses our main house, my next door neighbor on the left, the Grays, and the apartment and garage in question. A generation later, my mom and dad are now empty nesters and eager to retire. In fact, they are in their mid-70s and both still working full-time to make ends meet. They need my help and my wife's help. The property tax bill alone is over $18,000 a year. The house is too much for them to maintain alone, and the cost of living would force us to an alternative situation, But as we've planned for a generation, we intend on staying on the family property. As my grandparents sold it to my parents, they would like to sell it to my wife and I so we can raise our family there. And hopefully, eventually, my son can raise his family there. This is how my grandfather hoped it would be. Unfortunately for us, the 1980s shake of a hand at the building department obviously became very different from the laws and restrictions today. But it should be stated, and everyone here should understand, that our intention, our only intention, was to move the living space from the old cottage to the garage upstairs. This is a decision to retire, but not have to move to a retirement home. To keep our family together, and it financially is the only way we can make it work. Again, we are not putting a shovel in the ground. We are not changing the structures. We are not building anything. Everything we need already exists. We just need permission to update the electrical service, hook up to the brand-new septic system, and build the deck. Thank you for your understanding, and I understand that you're not taking any more because this was supposed to be submitted earlier, but it's a couple pictures of showing you the picture of the place.
We've actually been by it, so we've actually seen the place.
Okay.
Yes, part of our research. Thank you for reading that in. Okay, and I appreciate that. Hopefully, we can, again, when I was reading some of the notes by staff, they weren't really sure how or why everything was approved in '87. Hopefully, depending on the outcome of this meeting, we can rectify or make sure that that doesn't happen ever again.
Thank you.
So that being said, is there any questions from the board regarding this appeal?
What street is this located on?
The driveway is off of Babusick Lake Road.
What street is it located on?
Babusick Lake Road.
I don't see that located on Babusick Lake Road.
Oh, it would be Gooder Road? Gooder Lane?
An accepted town road?
No, it's a driveway. Like most lake communities have driveways that branch off.
I understand, but we're not looking at the hardship, and I can appreciate what you're trying to do with your folks. But we're looking at the specific RSA that states a street. And this looks to me like a landlocked parcel that's not on a street.
A majority of all the streets around
I'm looking at this specific parcel.
But part of the way that when the lakes were built, all the cottages had little
No, I understand
trails
that.
and things to them. So that's why we're trying to get the access. That's why Gray's, we engineered a plan for the access from the driveway with our own entrance into that. And so
Is that a
it will have a.
Is that a recorded easement?
It's engineered right now.
Is it a recorded easement?
No, it's being held in escrow pending the outcome of this hearing.
Okay.
But both sides have signed it, and it's being held in escrow until, and there are cross easements, by the way. We're giving out
Yep.
an easement on our end, and they're giving us an easement on their end. And this is not a technical street, but we believe the RSA makes provision for private roads. And we think we can meet the requirements of private roads under.
I don't see private road either. I see easement. I don't see road anywhere.
RSA 674:41, 1D. There's also a case law on this, so.
Okay.
And so if this is approved, it's just for note, if this is approved, prior to the issuance of a building permit, the original subdivision plan on file at the Hillsborough County of Deeds is plan number, and I won't get into that, shall be reviewed by the town's legal counsel and subsequently the planning board if deemed necessary after consultation with legal counsel. So if we move forward with the appeal or granting this appeal, the next step is that it is reviewed by town's legal counsel and subsequently could be a planning board thing as well to address the Private road.
I don't see a private road. I see an easement.
So I have a question for Robert. Does this set a precedence if it passes? And if so, what would it set?
It does not. In this case, this administrative appeal is set forth specifically in statute that they have to appeal to get a building permit authorized by the ZBA. So in this case, it's isolated from any precedent-setting instance. So that has nothing to do with this.
Okay. And just so I have a better understanding, was an appeal recommended over a variance, or?
The applicant or petitioner did file a variance initially, but because this process is spelled out specifically in state law, they were recommended by us to file an appeal for administrative decision.
So what you're saying is they can't request a variance?
Correct, because there is an actual appeal process already laid out in statute for exactly what they're doing.
Understood, thank you.
1D states is a private road. It doesn't state easement.
What's the difference? A private road can be an easement, it can be a right-of-way, it can be an easement by prescription. It's a way that's private.
Well, you're the attorney, and I'm not. I'm just on the ZBA.
Well, I don't get the last
Yeah,
the
I
last
understand.
word. That's up to a judge someplace.
I'm just looking
But
at this
that's my
saying,
understanding of it.
that's an easement, and that's not a private road because it's going across somebody else's property. So
Well, according to 1987, the property is accessible via an easement over 310 Babusick Lake Road. The portion of Jeb Road shown as frontage, the subject lot on the exhibit plan provided by the petitioner is only a paper street and is not actually constructed.
and there actually isn't an easement.
Right. Well,
On the plan, it states a gravel driveway. It doesn't state an easement.
okay. All right.
I'd like to find some way to do it, but I don't.
I think that it is worth pointing out that they could, well, if they weren't going to build a deck and they were just going to upgrade the electrical and they had a friend who could do that, they wouldn't be here at all, and they would just do it. But by following the letter of the law, they've now put themselves in a peculiar situation where something that was approved over 30 years ago
I can't disagree with that.
is kind of coming back on them.
Although what was approved was, the lot was to remain non-buildable.
No, that's not a requirement of the approval. How
I
could you,
understand.
how could you require it to be remaining unbuildable if you're approving a building permit in
Well, I
1987?
understand that. I'm just looking at the tax card here, which says estimated 3 bedrooms per plan. This lot was to remain unbuildable.
Well, that's someone's comment, because it's listed on the tax card as upper floor finished.
Yep, yep. And the plan, 12233, states unbuildable. So
Yes. But that's a private right of action that has long been extinguished.
you've got a cluster here, there's no question.
Is there any other comments from the board before we open up the public hearing?
And I'm going to go back to Robert with this. So, since they can't request a variance for this, if the appeal fails, it just stays the way it is?
The only way they could get a permit would be, that I could see, would be to upgrade something, either get Jeb Road constructed or get a road put in to access the parcel that would meet the letter of the RSA.
Because then they would have frontage.
Because then it would have frontage on a Class 5 or better road, or have some kind of private way that somehow constructs some access that complies with the way that the statute's written.
And our access to Jeb Road is extinguished. There's a building in the middle of it, so.
Yeah, so then it would somehow have to create some sort of access to be able to meet the letter of the law.
Understood. Thank you.
All right, I'm going to open up the public hearing. Unless you have something you want to add right before I do it? Kathleen, is there anything you want to add before? All right, I'm going to open up the public hearing. I'm going to read in 2 letters. First, we're going to speak with everybody who's for this petition. So I'm going to read in 2 letters that I've received. The first one is from Joseph and Margaret Schiffler from 25 Jeb Road. Dear Chairman, Vice Chairman, and board members, I am a neighbor 3 houses down from the Pauls. I have no problem with what they are appealing. I have been their neighbor for over 40 years. They've kept their property maintained and in great condition. They've been good neighbors and also protectors of the lake environment for all those years. I ask that you approve their appeal. We need more people like the Pauls in our lake community. Thank you. Very yours truly, Joseph Schiffler. The next one is from Joel and Ann Bedell. Dear Chairman, Vice Chairman, and board members, my wife Ann and I live in close proximity to Tony and Dave Paul. We would like to add our names to those that in favor of Dave and Tony converting their barn upstairs into their future retirement home. Ann and I lived in Merrimack for 32 years, 13 of them at our present address on Babusick Lake. Dave and Tony have always been respectful neighbors, always ready to lend a helping hand to people who live around the lake. Their house and buildings have been tastefully done and very well maintained. They are an asset to the community in which he and wife have lived most of their adult lives. And sincerely, Joel and Ann Bedell, dated 12/21/2017. Is there anybody else that would like to speak in favor of this appeal?
I would, but I didn't stand up in time to
Stand up.
raise my hand.
Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Why don't you come on down, gentlemen, if you could just let him have a seat there so he could sign in and speak, that would be great. You could just sign in and then just state your name for the record.
My name is Kerry Demers. I live in 19 Jeb Road, Merrimack, New Hampshire. And I've known Dave pretty much since I moved into Merrimack 35 years ago. And actually, he was my best man when I got married. Great guy. We've done a lot together on the lake. We both families have been on the board for Babusick Lake Association. So we understand what it's like to try to preserve the lake. We try to do the right thing for the lake. And I feel that what he did with the barn originally, moving it back off the lake, was a plus for the lake. And I don't think anything that he's doing is going to harm the lake or bother the neighbors. I don't understand why it's got to where it is, but I'm definitely in favor of it and don't see any harm in it.
Okay.
Thank you.
Is there anybody else that would like to speak in favor of this appeal? Come on down. If you just sign in and state your name.
Yeah, William Wenzel, 37 Scenic Vista Way, Merrimack. Same thing, I've known Dave my whole life. They've done nothing but try to improve the lake. I can't see them, same thing, I can't even see why anybody's even giving them a hard time. They're improving, they're going to a new septic. Nothing's changing. Like he said, they moved the camp from the lake back, so it's not like they're creating any harm to anybody.
Okay. All right. Thank you. Is there anybody else that would like to speak in favor of this petition? Just come on down.
Good evening. I'm Laura Dodge. I'm with the law firm.
Could you sign in first, please? Thank you.
Good evening. Laura Dodge, McLean Middleton Law Firm. I'm here tonight on behalf of Mr. Kenneth Gray, who owns the property at 310 Babusick Lake Road. We're not necessarily opposed or speaking in favor of, but I thought it was important to clarify for the board that we had negotiated and drafted the easement agreement providing access, and we do have a signed easement agreement that we're holding in escrow pending the outcome of this hearing tonight under the law, that access is considered a valid access under the statute, that it's a legal right-of-way that would allow them to access the proposed lot from coming from Babusick Lake Road to Gooder Lane, and then a newly constructed driveway segment that would provide access to that lot.
And that would provide the frontage that would be required for that?
Well,
or-
I mean, ultimately, the planning board is, the statute provides provisions that the planning board would have to approve, so that would be ultimately up to the planning board. But I just wanted to represent to you that we do have an easement agreement in place that provides that driveway to be constructed off of Gooder Lane, gaining access to their lot.
Okay, awesome. Blair, did you have a question?
No, that's fine.
All right, thank you.
Thank you.
Is there anyone else that'd like to speak in favor of this petition? Okay.
Can I
Sure.
ask Robert a question related
Please.
to that?
Yep.
No, never mind.
Okay. Question. Is there anybody who'd like to speak against this petition, this appeal?
You have 2 letters to read into.
I do have 2 letters that I'll read in. Why don't, actually, you know what, if you gentlemen don't mind, let me read these letters in real quick, please. Thank you. So the first one is letter, members of the board. I was a trustee working with Willard Jebb on the subdivision dated December 1978. The appeal violates the intent of the plan as described in the plan document, as well as the intent that Willard Jebb verbalized to me at the time. The land sold to all lakefront owners was intended as a buffer land only and specifically not for residential use. I am opposed to this appeal. Regards, Herbert Langer. And that's dated 12/20/2017. The next one, and if you'll forgive me, it's a couple of pages, single-spaced. This is from Elaine Krulup, 23 Jebb Road, Merrimack, New Hampshire. Dear board members, I am the owner of property identified as having an address of 23 Jebb Road, Merrimack, New Hampshire, which is nearby the property which is the subject of the above referenced appeal. The appeal is to allow to allow a building permit for a residence on lot 156-9 on tax map 6A2 to permit construction of a one-bedroom apartment on an existing garage having access to Babusick Lake Road by easement over private property or of others. I am opposed to the appeal. The proposal appeal fails to meet the standard of demonstrating that enforcement of the state statute imposes either practical difficulty or unnecessary hardship. Additionally, the proposed use is contrary to the use restrictions set forth in the property owner's deed and on the subdivision plan which created this lot. For background, as to the private covenants, I refer to the deed into Tony S. Paul, the current owner, dated July 31st, 2017, which is recorded at Book 8994, page 934 of the Hillsborough County Registry of Deeds. I have attached a copy of Exhibit A to this letter for your reference. The property of the variance application is identified as Tract 3 on page 3 of the deed. Please note that the legal description of the property refers to a subdivision plan recorded in the Registry of Plans number 12233, being the plan which actually created the property in 1978. I have attached a copy of the plan 12233 as Exhibit B to this letter. Also note that immediately following the description in the deed, as it states as follows: the conveyance is made pursuant to certain restrictions and covenants recorded with said plan dated December 12, 1978, as amended, and is subject to said restrictions and said plan being recorded in 1223 drawer 23 of the Hillsborough County Registry of Deeds. I'm going to probably try to skip all this legal jargon here. Hold on a second. Here we go. No owner or owners receiving title to these lands respectively shall convey said lots separately and apart from said owner's existing lot. A new lot and existing lot shall be considered one lot for purposes of further conveyance, transfer, or of device. Further note, number 9 states, no lot may be used for any temporary or permanent residence or dwelling, nor be further subdivided. Finally, note 11 states, these covenants shall be binding on all owners and heirs, successors and assigns, and may not be waived by variance, exception, or otherwise, and these covenants shall be incorporated in every conveyance hereafter. It is clear that the property is subject to these restrictions and no residential use should be made of it. Further, it is important to understand the background of these restrictions. My father owned all the land shown on Plan 12233 located just behind lakefront lots on Babusick Lake. He was concerned about the impacts on the use of the lake and values of the lakefront property should there be further development of these lots. He decided to subdivide the property and sell each of these lots created to the owners of the lots on the lake for next to nothing. This allowed protection from everything which the applicant is now attempting to do by appeal. Also, to the enforcement creating an unnecessary hardship, first, there is nothing unique about this property. I'd argue that. There are other lots exactly the same. They were all sold under the same set of equitable restrictive covenants enforceable by each of the abutting owners, and all the parties understand the restrictions in place. Each of these back lots in this neighborhood has had some problem, no frontage on public way, which you guys have. Even if the property is considered a unique parcel for some reason, the applicant must still approve the purposes of the statute requiring frontage on public way bears no fair and substantial relationship to the specific purpose of the provision when they apply to this property. In this case, the purpose of requiring frontage on a public way is clear: access for both owners and public safety vehicles, and is covered under NHRSA 44741, in that emergency vehicles need to have proper access to properly maintained roads for life safety purposes. The town of Merrimack does not want homes being built on lots where access is a problem. The town also wants adequate spacing between homes, which is created by the frontage requirements. Here, there is no public way, and the private easement is a significant length, so enforcing the ordinance provisions require frontage have not only to fair and substantial relationship to the intended purpose of the ordinance, but direct connection to the relationship of the purpose. Finally, the board must decide the proposed use is reasonable given the restrictions of the statute and restrictions on record prohibiting construction of a building, overturning the administrative decision, thereby allowing a residential use in an area which was clearly not intended, is not a reasonable use. Besides violating the restrictive covenants, it is a bad location for an apartment use. The alternative argument under hardship is where there is no reasonable way to use the property for what it is zoned, creating a hardship because there is no reasonable return on investment in the property owner. Here, while the lot is zoned for residential purposes because the frontage requirement cannot be met, it cannot be used for residential purposes, but there is no real hardship or practical difficulty in this instance because of the restrictive covenants on the record and acknowledged by the owner. However, if the covenants did not exist, the applicant could satisfy the requirement by constructing a roadway. What prevents construction of the roadway are both the restrictive covenants preventing such as well as the area in which could be dedicated to a public way. Is the improvement too costly to the owner? Is the applicant entitled to a reasonable return on its investment? Here, the restriction meant that the value of this lot was negligible. The owner has already obtained use by building a garage, and this is equal to putting a second home on a single-family lot. The proposed use is not reasonable use, and the relief requested is unreasonable and does not satisfy the terms of hardship argument. This appeal should be denied. Thank you. Yours truly, Leon Kurlik.
Can I ask a question regarding something that was in there?
Sure.
So, is there a board right now that is enforcing these covenants? Do we know?
No. These are conundrums wrapped in.
Well, because isn't there a certain period of time where if there's no board managing the covenants, then...
I don't know of anything like that.
Well, I remember Tim bringing it up in an earlier meeting.
Okay. Is there anybody else who would like to speak against this?
Just for the record, I do have to state that the author of the letter was talking about variance criteria and a lot of that, and that does not apply
Not
to this
applicable
case.
here. Yeah.
And you did read a letter from Herbert
Yes.
Langer?
Yes.
There's also one from Lynn.
Okay, sorry, one more. I'm not a direct butter, but I do have a parcel of the subdivision in question. My feeling is that should this appeal be approved, it sets a precedent for other lots in the subdivision to be developed the same way. Should that happen, my property values and quality of life that I have expected because of the covenants will both be compromised. The land sold to all lakefront owners was intended as a buffer land only, specifically not for residential use. I'm opposed to this appeal. Lynn Langer. Now, I believe there's a gentleman that also had his hand up. If you'd like to come down, please sign in and then state your name, please.
Good evening, Mr. Chairman, members of the board. My name is Morgan Hollis. I'm an attorney in Nashua, and I'm here representing Ellen Kurlop, who wrote a letter and submitted it, and you have received it. And she was traveling. There was some concern whether she'd be here, but she's asked me to represent her, and she did make it back from her travel. So she's here this evening as well, should you have any questions of her.
So the letter that I read in by record, as it was pointed out by our staff, it talked about hardship, and it talked about other points that are in regards to variance. That does not apply to this particular situation. Although the letter has obviously been read into record, some of the points that were brought up there are not points that would be considered for this, based upon that there is no hardship, there is no. That's for a variance, and we're not looking at this for a variance.
Well, I can appreciate that position, but with all due respect, in determining whether or not an appeal is to be granted, that is, you overturn the decision of the building inspector, you must find hardship or financial difficulty.
Well, we're not overturning a building inspector. What we're overturning is
The
appeals
zoning
decision, is our community development's decision, based on the fact that where they're looking to build, in that there's no frontage, there's an easement, and so the decision's based on that, and because their zoning, our community development center goes by the letter of what they have in front of them.
So my question, Mr. Chairman, is this an appeal of his determination that the easement doesn't fit as a private road, or is this an appeal that the property does not have frontage on a public way? Because if it's an appeal that it does not have frontage, which is what I understood the appeal to be, 674-41 Roman 2 states, whenever the enforcement of the provisions of this section would entail practical difficulty or unnecessary hardship, and when the circumstances of the case do not require the building, structure, or part thereof to be related to existing or proposed streets, the applicant for such permit may appeal from the decision of the administrative officer having charge of the issuance of permits to the Zoning Board of Adjustment. And it goes on to say, in accordance with 674-14-15, that is, that's how you exist. So my point is, whenever the enforcement of the provisions of this section would entail practical difficulty or unnecessary hardship, that's the criteria that you must find in determining whether to grant the appeal or to support the building administrator's decision. If you don't find practical difficulty or unnecessary hardship, then you must side with the building inspector, with the code enforcement administrator's decision. So unnecessary hardship is a criteria that you have to review. And there are cases that say the only definition of hardship follows along the lines of when a variance is requested, hardship is one of the criteria. That's why discussion of hardship is relevant and important, because the applicant has to make the case that they have a hardship here, and you have to find that there's a hardship. So those standards that are enunciated in that letter, the standards of hardship, which you're more familiar than I am, because you listen to them every month, the standards of the hardship are set forth in that letter, and you have to find that it's unique, that it bears no relationship, that there's a reasonable, that their proposed use is a reasonable use of the property, or that there's no other use that could be put to this, and therefore relief must be granted. That's why they're referenced in there. So, as I say, I respectfully disagree with the administrator in that hardship is in the statute. I think that's what you have to define and determine tonight. That having been said, I don't need to reiterate everything in the letter because I helped Mrs. Kurlop write the letter. But I would like to say that it appears from the get-go that part of the appeal this evening is based upon an argument that the facts in the case as set forth by Mr. Price are inaccurate. And what we have are copies, maybe we're missing something, but we have copies of an application for a permit to build, which was filed by David Paul back in 1987. And I'm going to submit this. It is in the official town record, but I'm going to submit it for tonight's hearing. And what it says is it's an application dated 6/30/1987, and its purpose is to build a garage. It goes on to say, erect a 36 by 48 gambrel barn. It says, style of architecture, gambrel. Number of families, 0. Garage only. That's what the application says. Total valuation, $20,000. That was the application signed by Mr. Paul and submitted, for which he paid his building fees based upon his application and his statement to the town of what he was building out there. I also have a copy of the building permit, which was issued on September 18th, 1987. On that states the applicant, David Paul, applied for a permit for a 36 by 48 garage. It was signed by the building department as having been issued to build that garage. There's a picture of the garage with no windows for residential, and the supporting documents are all in support of a garage. There are trusses and beams and shown on. I also have a plan, which is in the file of the town, which says, sketch showing proposed barn, map 6A-2, lot 156-9, Jeb Drive, Merrimack. It's prepared by George Keller, and it shows the proposed barn. It doesn't show anything about a residence, a proposed barn. And the barn is in the back lot. It is not shown as being occupied within Jeb Way. My client's not aware of what buildings are referenced as being located within the private right-of-way known as Jeb Way. I also have an application for a variance which was signed by David Paul and Tony Paul. And in that application for a variance dated 8/14/2017, which was withdrawn, but which was signed by the applicant, it states a variance was requested to permit construction of a one-bedroom apartment on an existing garage with paper access to Jeb Road. It says, under granting the variance would not be contrary to public interest, the construction of the one-bedroom apartment over the current garage will increase the tax base and revenue to the town. This is a statement of the applicant, which seems to be somewhat significantly different from what the statements made to this zoning board tonight are. I think the record is clear that it was a barn that was permitted out there, a 3-car garage. If people have been occupying that, they've been doing so without an occupancy permit, they've been doing so without a building permit to build the residence, they've been doing so without any permits from this town. They can make all the statements they want about people who've let things go by, but what they've stated to the town, not only in 1987, but as recently as this fall, is that they plan to build a house up there in an existing garage. We get here tonight and their statement is, it's always been there, nobody's ever objected. I don't think you can contradict a record. You can't say that someone issued a building permit for a house when the record says it was issued for a barn. So I want to lay the record straight and what the facts are, and in support of Mr. Price's determination that, in fact, no permit of record shows that there is a house ever allowed up there, and anybody who's been occupying that way has been doing so illegally and without permission of anyone. Let's talk about the sort of background, which I understand most zoning boards are reluctant to get into private covenants. Those are matters of private enforcement. A question was asked by one of the members of the board as to whether there's any body out there enforcing it. There was never a homeowners association ever created. The documents of record, again, are the deed in which every owner bought these lots and the plan by which they bought. The plan, I have a very large one so that nobody can say they can't read the fine print of a smaller one, but the plan of record is pretty straightforward. Mrs. Kurlop's father, Willard Jedd, owned land. Let me show this to the board if you can just bear with me. These were all lots along the lake, Babuzik Lake. There's for want of a better term, a private way laid out here. It's not laid out as a public road, doesn't show as a public road. It's a private way or some reserved area. And on the other side, Mr. Jebb owned all of the property which is to the backside of the lake lots. And what he decided to do was create all of these other lots on the opposite side and then sell them off to each of the owners. And he did so through a trust arrangement, and you read a letter from the gentleman who was the trustee at the time, Mr. Langer. Mr. Langer held all of the lots, and then he conveyed them out to each of the owners. So it wasn't Mr. Jebb going and he created the 10 lots, sold them to Mr. Langer, and Mr. Langer conveyed them out to each of the owners. But what was very clear was on the plan, which was approved by the town, first of all, it shows the little zigzag, which you might see, some of you might be familiar with on plans of record, where lots are to be connected and combined. So all those lots have connections. That means they're one lot. That doesn't mean they're separate lots. They're all one lot. You also have notes on the plan which says the intent on this plan is to divide parcel 5-8, which was a larger lot, as shown on the aforementioned plan, into 10 non-buildable lots, each of which will be acquired by an abutting lakefront owner. That's note number 5. Note number 7 says each new lot as shown in this plan shall be conveyed only to the owner or owners of the existing lots as designated. Number 8 says no owner or owners receiving title of these lots respectfully shall convey said lots separated apart from said owner's existing lot, and the new lot and the existing lot shall be considered one lot for purpose of any further conveyance, transfer, or devise. So there's really one lot here. The lake lot and the back lot are one lot. That's what was approved by the planning board. The planning board isn't going to approve a plan creating, in 1978, creating all of these lots as separate lots with no public way, no access to it. The only way it was created was, you can't build back here, folks. That was not only the intent of Mr. Jebb, that was the intent of the planning board of this town at the time. No lot, number 9, no lot may be used for any temporary or permanent residence or dwelling, nor may be further subdivided. No owner or owners shall request the town of Merrimack to construct, repair, or replace the roadway shown on the plan which abuts said property, and these covenants shall be binding on all owners, their heirs, successors, and assigns, and may not be waived by variance, it's a word in there, by variance, exception, or otherwise. And these covenants shall be incorporated in every conveyance hereafter. These aren't merely the words of the property owner. These are the requirements imposed by the planning board when they approve the plan. That's how this lot came into being. That's how this lot existed. It is not a separate buildable lot. It's not a separate building lot. Whether you go by covenants or you go by restrictions on a subdivision plan of record, that is what exists out there today.
So just so I understand, those are set by the planning board. Those are not covenants.
Those notes are incorporated in an approved plan, which make them a condition of the plan. They do not
That was approved by the
disappear.
planning board.
Okay, so it's approved, all right. The only reason I asked is because that sounds like something that'd be very good to bring up in front of the planning board.
And that's, as I say, a signed and
It
recorded
was.
plan. Now, whether the planning board wants to enforce it, that's their decision, however they may feel. Whether the town wants to enforce it, that's their decision. There are many plans of record, I'm the first to acknowledge, that have conditions of approval that are not enforced. They are enforceable, but not enforced. Not every town can enforce every covenant or chooses to enforce every restriction or condition of approval. However, those are conditions of this approval because they're incorporated as part of the plan. So, in answer to the question, could be enforced by neighbors. It could be enforced, and the covenants go on to say what they're there for. They can be enforced by neighbors, by owners of record, by the town. Those are all enforceable, but there is no homeowners association that monitors this whatsoever. So, moving to why there's opposition and why we don't believe that the appeal should be upheld and the administrator's decision overturned. First and foremost, as I say, this is not a separate lot. It was originally created by a plan of record, approved by the planning board. Those notes that I read make it quite clear that it is to be considered as an integral lot. So you're going to, if you overturn the administrator and the neighbors choose not to enforce covenants or the town chooses not to, you're creating two houses on one lot out there. The plan was to provide backside protection from development, but only one lot, not two. Because of those restrictions that are both in the deed and the plan, there's really no ability to argue that there's a hardship in this case. The owner recognizes it in the deed. The owner acknowledges it when they accept the deed. The plan is clear what it says. There's no question that everybody knew what was going on out there. To now seek revisionist history that somehow I got a building permit, there must have been a nod or a handshake or a wink that I could turn this into a house, and now, therefore, I'm coming to you to legalize it. That's just not how it works. That's not how the law works, and that's not how you function. That's not your purpose, to make things right that way. There is no hardship argument when, in fact, you have a reasonable return on your investment. This lot was not sold as a building lot. Many times people come before you, as I do, representing applicants, and they make the argument of hardship, which is, I have a reasonable investment in this property, and because of the ordinance, I can't get a reasonable return on my investment. And you have to demonstrate what you've paid, and you have to demonstrate what the restrictions prevent you from doing and allow you to do. And at the end of the day, you all make a judgment, is that fair and reasonable? And if it's not, we should be giving relief. And in this case, you have to look at what did they buy? They bought a lot that's non-buildable. They've known it's non-buildable. They've known they can't have a residence. So what is the hardship if the administrator says, sorry, you can't build there because you don't have a public way or you don't have an access way? I'm just not going to let you do that because the statute says I can't. What's the hardship that you can find here this evening? Now, maybe they have an alternative course to go, but in terms of your decision of whether to uphold Mr. Price's decision, they have to meet that hardship criteria, and they simply can't because they got this land for one purpose. They've owned it all these years knowing that purpose, and now they want to change that purpose. And that's not a hardship. Second of all, lots were never created for the purpose of occupancy, and no owner should request the town to construct, repair, or replace the road. There is a way out there, and I heard testimony earlier that that way doesn't exist because there's a structure in the middle of it, and I guess that's kind of news to my client, but assuming that there is some structure encroaching on it, it normally would be the choice of the applicant whether to build the road. This statute is in place so that the fellow or woman who owns 50 acres in the back and has accessed that farmland by a private road or a Class 6 road over the years and now wants to build a house on it can go to the town and say, look, you can't, it's unreasonable that I have to build 1,600 feet or 2,500 feet, lineal feet of a public way when no one else is going to be on it by me. And this board can say, you see, that's practical financial difficulty or unnecessary hardship. It doesn't make any sense to make them build a public way, pave it, have the town take care of it, or town can choose not to take care of it and make it from class 5 to 6. But it doesn't make any sense, so that's why you grant relief. This is not the case here. There is no basis for them to make that kind of an argument because they have a lot, they have a reasonable use of the lot, they have a garage on the lot. That's all they're entitled to. That's really all they knew they were going to get when they bought it. They can't now change the course of history. In essence, it's not the zoning ordinance, it's the state statute that limits the use. And the state statute has a purpose. And the argument is we can't use our property for what it might otherwise be used for, but for the state statute. What could they otherwise use it for? A barn, a garage, not a habitable building under the restrictions by which they bought this property. So they don't really have the hardship or the financial difficulties in their argument, and that's why I don't think you can overturn the administrator. I don't think you can uphold the appeal, and you have to, in fact, uphold the administrator's decision. There are small lots on private ways out there, as in other parts of the town, and that's bad enough. Many of these are camp lots that existed prior to zoning ordinances of minimum lot size, prior to even the state statute, which was passed before 1987 with regard to frontage. There are lots of pre-existing abnormalities that make it difficult for law enforcement and fire safety to get fire trucks down there, police officers. You've probably heard it over and over in this town and other towns. That's why they put that statute in, to prevent those situations from coming up. You have to make them demonstrate why they deserve relief under the statute from the zoning administrators, the community development decision with regard to, I'm not going to issue you a building permit. That's not a low bar. That is a high bar that they have to meet. Finally, while I understand and appreciate the personal difficulties of transitioning generational homes, and I spend a lot of time with clients trying to deal with that, the hardship expressed of a family wanting to stay and not having any other options is an unrealistic argument. And while that may be an honest, straightforward argument today, circumstances change, families change, generations change, financial needs and financial abilities change. Essentially, what may exist today as a family compound, if you will, of 2 houses on a single lot, sooner or later will not be a family compound, and it will be in here for a subdivision, a relief to allow the lot to be subdivided. The minute you open that door, you create the possibility of 2 separate houses on a lot, which at some point will either be leased out or separately owned somewhere down the line. If it's leased out to people who are not part of the ownership of the front lot, and you've introduced a whole different element, which was why these restrictions were put in. They never would have conveyed this lot but for those restrictions. I'm happy to answer any questions, and as I say, my client is here to answer any questions that you may have about her letter or me.
You make some valid points, and all I can say is and I've said this multiple times sitting up here, we make a decision based upon the here and the now, not what's going to happen 10 years, 20 years, 30 years down the road. You did point out things change, and quite frankly, I hate to break to the people in Babusick Lake, it could change. That land could get subdivided. You could have somebody who could buy up a bunch of properties. We could sit here till now until midnight and discuss all the possibilities that could happen. The Babusick Lake area, the community is a very nice community, very nice environment, but things change. People come forward for variances. People could subdivide those lands out. We don't make our decisions based on what could happen. We make our decisions based upon the information that's provided to us where we're at right now and here and now. So you do make some good points, but you also do bring up a good point that things do change. And a lot of the laws and a lot of the zoning ordinances that were put in place many years ago, well, long before any of us were on this board, some of them are a little antiquated, and we are seeing those start to change as it changes in Merrimack. So I do appreciate it. You do bring up some very good points, and I appreciate you. You bring up some very good arguments as well. And I'm sure that this isn't the last time that we're going to be hearing about anybody on Babusick Lake doing work, as we have had multiple cases about people upgrading homes and building new homes and things in the lake area. So I'm sure that's not the last time. Were there any questions? Well,
Mr. Chairman, could I submit these documents I referenced?
we're not accepting any documents. This is in the preamble. We don't accept any documents the day of the
That's
hearing.
fine. Then I make
Would appreciate
reference to them that they are in your official records of the town of Merrimack.
And
you should take
that's on file, so if
And
we
you
do.
should take
you should.
judicial notice of those records. I'm just
Okay.
pointing out what's in your records.
I appreciate it.
Thank
Thank you. Is there any questions? Is there anybody else that would like to speak against this petition? Come on down, sign in.
Yeah, I just wanted to say my name's Jeb Kurlop, and I live at 23 Jeb Road. My grandfather, Willard Jeb, actually came up with this subdivision in 1978. At the time, there was a major development that had gone on at the south end of the lake, and there was it's called Four Seasons. And he was disturbed because he could see that the quality of the water was changing. And so a couple of years before he died, he put together the subdivision in 1978. And then he basically left a section of land behind the 10 abutters, which he essentially gave to them for nothing. And with the intent was that to preserve the integrity of the water, protect the watershed. Also, there were a lot of changes that had gone on. I mean, back when he moved on the lake in 1942, people were coming up there for 6 or 8 weeks of the year. By the late 70s, people were beginning to move in full time, and the infrastructure, the septic systems, wells, etc., were not really were adequate for that length for what they were originally designed for, basically. But he really did this with the best of intentions in terms of just preserving the lake for the abutters, and also that was his intention. So, tonight when we first got up, the first thing we said is you had us get up and you had us take an oath to tell the truth, the whole truth, and nothing but the truth. And tonight I've heard a lot of liberties taken with the truth. Yeah, I've heard a lot of liberties taken. And also Attorney Hollis had come up with the garage permit. We were told earlier this evening that it was for a dwelling, for residence, which clearly, based the documents, are the facts. And it was not for a residence, it was for a garage. And I would just like to ask the town to take all of that into account when you're making your decision. Thank you very much.
Thank you. Ma'am, you'd like to
Hi.
state your name?
I'm Jan Langer. I'm a director butted to the
Can you
property.
make sure you're speaking to the mic? That's okay. That's
I don't
okay.
like being here.
Makes two of us.
Jan Langer, I'm a director butted to Dave and Tony to the property that's in question. There's nothing I like about being here. The thing I dislike the most is having to speak up against my neighbors. I'm not at all comfortable, and I find this very distasteful. But I feel very strongly that this should not be a residential property, partly based on the fact that Mr. Jeb very generously gave over all of this property to all of us as buffer, and for uses for our septic systems. If it weren't for him, the properties wouldn't be worth anywhere near what they are right now, because they were all 50 by 100-foot lots and nobody had any room for a septic system. So I think we have to keep that in mind. And the reason that they're going in on a 3-property septic system over there is because they've built on some of that land. And a lot of us don't have any space. One business thing, Joe Schleifer did write a letter in support, but he failed to tell you that he's Tony's brother, and I think that's important. The other thing I want to just say that I agree with everything that Attorney Hollis had to say, 100%. The barn wasn't challenged years ago when it was built. It probably should have been, but none of us wanted to ruffle any feathers, and you just kind of go along and get along, and it wasn't really offensive, but having it become a residential space that can be sold off at some other time is offensive. It's not what we bargained for, and it's not what we want. The only other note I had here is that Joe Bedell lives about a half a mile away. This doesn't affect him at all. And he wrote a letter.
Yes.
I think that's all I got.
Okay, thank you. Thank you very much. Does anybody else would like to speak against this appeal? Okay, if you'd like to come up and answer, you can address some of the concerns that were brought up.
It's ironic that Ms. Langer is here to oppose this petition because we gave up our access to Jeb Road for this lot so that she could build a garage in the middle of what was formerly Jeb Road that she enjoys for the last several decades, and that's where our access to Jeb Road terminated. We think that the plan clearly shows that these lots are separate and they're not part of the same scheme. The town taxes them as separate lots and has taxed them as separate lots since they were subdivided. They are done by separate deeds to each one of the people who own these subdivided lots, and they are not joined by any current covenants. There are notes, as Attorney Hollis went through on the plan, that create some common responsibilities among them, but we think those are private covenants and not historically enforced by the town. With regard to the criteria that need to be met, we think that this does create or has been subject to a unnecessary hardship and a practical impossibility because we don't have any other access for this road because we are trying to help out Ms. Langer with her wanting to have a garage. So we have no present access to Jeb Road, which is an original design of the subdivision, but again, we don't have that anymore. So we need to have this lack of frontage and our easement to the Babusick Lake Road approved. This lot's got a long history of use as a residential unit, well beyond the 20 years that would be required for someone to sue to stop them under state statute. And we're asking now that you continue the use that's happened since 1997 and allow us to make some changes which continue to improve this particular lot and the residences around Babusick Lake itself. Care to add anything?
Yes, and it should be noted too that our main house, one of the reasons why we want to do the additional road access, driveway access, is because our main house has the easement through it. We have to go through Gooder Lane to get to the main house and the garage. So by adding this road in, it's going to make it safer for everything, including fire access. It'll be a road that's already engineered to those standards. Also, everyone keeps forgetting we replaced the old cottage with the garage. The town told us we could put a new garage there, and you're going to have to reconfigure some of the septic over the years. You're going to have to deal with that, but they at that time told us, yeah, we constructed the barn as the garage as a garage with the intent of having the apartment there later, because we had a whole separate lot on the lake. Remember my Uncle Harold's cottage that we bought? We bought that and tore it down and put the garage. So this whole idea of not having enough land there, we could have put a whole nother camp there, as everywhere around the lake has been doing. You guys do the variances all the time for builders around the lake to squeeze it in, to get it up to today's standards, to put the new septic in. That's all we're trying to do. I mean, since '96, we've been paying taxes as living space. We're not trying to hide anything from anyone, including all of our neighbors. We just wanted to improve with the new septic system.
Questions? So I'm just kind of curious because it was brought up by Attorney Hollis. There was the original, this may not play a bearing, I guess, but the original okay to build the garage, the original variance was to build a garage, but there's nothing stated about a residence. But you went and put the residence anyway. And then he also stated that you put a variance in earlier this year, by the sound of it, to have a residence put in there, or to build an apartment in there. Then you pulled that variance. Just curious about
Just
that.
because it changed. Robert can probably say this because it changed because it was a.
Yeah, that was the staff recommendation to them to withdraw that request and go the administrative appeal route because of the way the statute.
And that was
language
from earlier this year.
Right.
Okay.
They first approached us with the variance application. We looked at it. We spoke to our legal counsel briefly, who advised us to advise them that the administrative appeal route was the appropriate one.
Thanks for clarification on that. Questions? Thoughts?
So I guess the thing that I'm still kind of confused by, was there no variance to put some kind of an apartment on top of the garage that was ever filed, or was there never?
I'm not aware of any previous variance on this property. They went and sought a building permit, and the building permit was issued for a garage. That's all that I'm aware of.
Okay, so the building permit was explicitly for a garage.
Yep. Yeah, what Mr. Hollis represented tonight was what we are aware of in the building department's files.
Okay, thank you.
Any comments on that?
Just that we've been paying taxes as living space on that apartment, and it's been occupied since '97. And I would assume the town would want to keep that tax base.
You're paying taxes on the garage. I mean,
No, on living space of the apartment.
Who's living there? Or who has been living there?
Well, right now it's under remodel, but we've had extended family members and just tenants over the years.
So you've been renting it?
We've been renting it.
Okay.
And the notation on the tax card does say upper floor finished.
Does.
Yes.
Okay.
Yeah.
All right. Any other questions? All right. Anybody else want to speak against?
What about if we've been paying, just a quick note,
Go ahead.
if we've been paying property taxes since '97 or '96, wouldn't the town want to keep that tax base, or would we have?
We're not.
Yeah, that's not relevant.
Yeah, that's
Sorry,
not relevant.
sorry.
That's not relevant.
Not their issue.
Sorry.
Any other questions for the gentleman? If you could just have a seat, I think there's some other people someone else like to speak. Did you want to come up and add anything else, Attorney Hollis?
I don't want it to go on, I just didn't know whether you allowed it.
Nope, sure, come on up. You can. This is the public portion of it.
Thank you. Just briefly, I think they made the statement that they made the decision to give up so-called Jubb Road. That was their decision. That, again, gets into, if there's a hardship out there, it's a hardship created by their own decision to do whatever they wanted to do. They didn't have to do what they did, allegedly giving up Jubb Road for a construction of a garage. So that's a decision they made.
That's really not relevant. However, if we really want to take 5 minutes to go down that road, I mean, in the effort of being nice to a neighbor,
Well,
I mean, which was brought up by another neighbor, kid along to come along, that type of thing. So if they did that because they didn't think that they'd be sitting here how many ever years later arguing over putting a porch and new electrical into a finished upstairs of a garage, I mean, they may have thought differently.
You might have to hear from the person who actually was involved in the transaction.
Right.
The point is, as to the matter of my bringing up the variance application is not what the variance was for or whether they should have filed a variance. It's for what they stated on the variance application. These are statements that are made in the public record which says they are going to build a house. It doesn't say we just want to make renovations to an existing house. They made a statement. That variance application, which is a public record, is a statement that they are going to build an apartment up there. That's different than what they've stated here on record. Again, I'm only pointing out what's of record and the inconsistency of the statements that have been made versus what's been stated to you this evening.
But that was pulled.
It was pulled, but it was a statement submitted to the town, filed with the town. You can't just make a misstatement of fact and put it into a public record and expect it not to be, oh, well, sorry, you maybe forgot what you were here for. That's a statement that has to be weighed by this board when accepting their testimony. In a court of law, it would be called credibility factor. You have to weigh the same credibility. If the permits of record state that this was for a garage, if the statements to the building department in a variance application state this is to build a residence, and now tonight they're saying, oh no, we've had a residence there and everybody knows about it. You have to weigh all of those factors when considering the credibility of the witness here this evening. Finally, the tax card. Tax cards recognize what the assessor knows is out there, but it doesn't legitimate necessarily. It's not a town putting a stamp, this is a permitted use. It's simply legitimizing. There are people who have homes that are not taxed for what they have, and they don't run in here and tell the assessor. It's the same thing. That assessment card is not an official record of what has been permitted or is allowed out there as a matter of law. So to state that because they've been taxed that way, therefore legitimizes their building use as an incorrect statement of law.
No, we don't even take that into consideration.
Thank you.
Thank you. Anybody else like to speak against this petition? Okay, I'm going to close the public hearing. Discussion from the board. Lynn.
I'm going back to RSA 674:41, which is really all we're talking about tonight.
Okay.
For purposes of paragraph 1, street giving access to the lot means a street or way abutting the lot and upon which the lot has frontage. It does not include a street from which the sole access to the lot is via a private easement or right-of-way, unless it's also set forth in subparagraphs A. So I think we've gone a little bit further to say this private road does not include, or at least this is how I'm reading it, and I'm not an attorney, so I think we go down to, and I'm not going to get into the legalities of this lot and whether you can build on it. That's not our decision. I'm not getting into the current use or how we've been taxing it. I'm just looking at the community development's decision that says, per RSA 674, you can't do this.
Okay.
Now, I can appreciate what they want to do. I like it. I love having families stay together and keep it. There's enough property here that I think it's reasonable, but based on the law, I don't think we have a choice.
I'm going to ask a question to Robert. So, for clarification, in the tax card it says estimated 3 bedrooms, but the lot was to remain non-buildable. Is that the tax assessor's way of saying, hey, I didn't know this was here, it looks like it might be 3 bedrooms?
I'm not them. I don't know what their notes really mean. That's their own record. It could be that, or it could be just referring to what the subdivision plan note says. I can't speak for them.
What about the, sorry, I forgot your name. She said that they're holding in a right-of-way in escrow.
But that's what 674:41(3) addresses.
Street on a street plat.
Yep.
Made by and adopted.
The street does not mean a private easement or right-of-way, and that's what we're doing here, is a private right-of-way easement. It's not a street. This lot is landlocked. It has no access, or it has no frontage on any street. It is only accessed via a private easement across the adjacent lot. And while that's all well and good for now, but if in the future, if these are sold, you know, that's going to vary. But we're not talking about the future. We're talking about right now. What we've got is a building permit that says a garage. Whether they should have done that or not, I'm not going to address that. I'm just saying right now they're asking for the legitimization of a residence, whether it's adding electrical, whatever they're doing, they're asking for legitimization of a residence on a lot that is not on, does not have frontage on a road, and they don't consider an easement as an exception to that. So I don't see how we can do this, much as I would like to.
Okay, so if you actually go a little bit further, in RSA 674-14, Section 3, the section shall supersede any less stringent local ordinance, code, or regulation, and no existing lot or tract of land shall be exempt from the provisions of this section except in accordance with the procedures expressly set forth in this section. For purposes of paragraph 1, the street giving access to the lot means a street or way abutting the lot and upon which the lot has frontage. It does not include a street from which the sole access to the lot is via private easement or right-of-way, unless the easement of the right-of-way meets the criteria set forth in paragraphs 1A, B, C, D, and E.
Right.
So that actually goes to
What's
solidify what
detailed.
you said.
Yep.
That being said, what is any other discussion points? Anything else people want to bring up? And if not, can I have a motion?
I'll make a motion that we uphold the decision of the administration and deny the appeal as per the requirements of RSA 674:41. That the RSA states that the building permits cannot be issued to lots not meeting a specific requirements and outlines an appeal process to the Zoning Board of Adjustment. Parcel is located at 312B, Babusick Lake Road in the R Residential District. Tax map 6A-2, lot 59-9, case 2017-34.
Do I have a second?
There's another piece.
Should the board approve or not?
Should the vote to deny?
No.
Oh, yep.
If you want that read in, that the petitioner would not,
No.
You don't need
I don't think we need to.
No, that's only just explaining to you guys
Right.
what happens based on how you would vote in either case.
Do I have a second?
Second.
Okay, call for a vote. All in favor of
Denying the appeal.
denying the appeal, say aye.
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 All opposed? Aye.
Aye.
It's 2-2, it's dead. Since there's only 4 on here, the appeal is denied. All right. Discussion possible action items of concern. Actually, you know what? I'm going to give a 5 minutes, just let the room clear up, please. 5 minutes, let the room clear out. Thank you. All right, so we're going to go, all right, so I'm bringing everything back. All right, so discussion possible action items concern anything from community development. Okay. We have the approval of the minutes of November 29th, 2017.
Motion to approve.
Second? As printed?
All in favor, say aye.
Aye.
Actually, you have to abstain.
I have to.
Because you weren't here for the November
Okay,
meeting.
well, I thought, I read the minutes. I
no,
thought-
but
She could, she could see it, right?
She
Read it.
watched it, she can vote.
All
I
right.
did watch it on television.
If you did, then you actually can vote.
4-0-0 in approval. All right, anything else to discuss or bring up? Okay.
I guess, welcome Kathleen.
Yes, welcome.
It is definitely nice to see a new face on the board.
Thank you for sitting in tonight
Yeah.
as well.
Yeah.
You got a name tag already? You're
You
awesome.
you didn't get a practice. You were thrown right in,
You got
Right
thrown
in the fire.
and on a difficult one, no less.
You know what, it was kind of difficult because I didn't like when people started calling each other liars. I don't like that.
You get used to it. All right.
That's not true. That you don't get used to it.
Anyway, thank you very much, Fran. I hope you're feeling better. From the zoning board in Merrimack, Happy New Year, everybody.
Happy New
Good
Year.
night.
Need a motion.
Wait,
We haven't
wait.
actually.
Oh, we need a motion.
Motion to dismiss.
Motion to dismiss.
Adjourn.
Motion to adjourn. I'm sorry.
Adjourn. Seconded. Motion adjourned.
Can I vote on
All
this
in
one?
favor,
Yes.
say
Aye.
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 All right. Have a good New Year, folks. Thank you.